I will call the House Committee on Judiciary to order. Madam Clerk, will you please call the roll?
Chair Lightner.
Yes, here.
Representatives Begol.
Here.
Wozniak. Harris.
Here.
DeBoyer.
Here.
Johnson. Here. Schutte.
Here.
Carter.
Here.
Hope. Here. Breen. Scott.
Present.
Madam Chair, you have 9 members present. You do have a quorum.
Thank you, Madam Clerk. Next, we're going to move on to the minutes of the meeting from March 5th. I have a motion from Rep. Carter to approve and adopt the minutes from the last meeting. Clerk, would you please call the roll? We don't take it here. Sorry. Not used to that. It's so weird. Okay. Well, without objection, so ordered as far as the motions from the previous minutes. Or the minutes from the previous meeting, sorry. Rep. Begol moves to excuse absent members. Hearing no objection, members are excused. Next, we will move on to our agenda, which will be House Bill 4070, sponsored by myself in regards to juvenile indigent defense. So we'll go to these for a moment so we can switch out.
The House Judiciary Committee will come back to order. Madam Chair, if you want to introduce your guest, and then the floor is yours.
Sure. This is Kristen Staley. She is from the MIDC right now. So she's kind of going to be up here testifying with me just as assistants. And also then after we take the vote, she's going to go into a presentation of the overall MIDC program. So the bill you have before you, House Bill 4070, is a reintroduction from last term. So last term I was part of the Juvenile Justice, or 2 terms ago, Juvenile Justice Task Force. And we come up with recommendations for the state to move our state in a better direction as far as juvenile criminal justice, I guess, to help avoid the pipeline to prison. So my bill was one of 20 that I worked on with numerous stakeholders around the state and country. 19 of those 20 bills actually got through the House and the Senate and were signed into law. 4070 was stalled in the Senate for a year, really with no good reason. So I don't know why, but last minute it did get voted on in the Senate and it did get sent over to the House for concurrence. However, as you all know, we had a little line in the sand in December, and therefore this bill was not concurred in and therefore not signed by the governor. So today is a reintroduction. And what this particular bill does is it brings parity to the system with the juvenile system and the adult system for indigent defense. As you know, you are entitled to representation in the court system, even if you cannot afford it. The problem we have in Michigan is there's no standards for juveniles right now. And as some of you may or may not know, processes can be different. Waivers can be different. Just the educational piece with attorneys and programs that are available, diversion, all different types of things are out there. But some of these new attorneys who are court appointed might not necessarily know that. So again, this brings parity to the system so we actually have standards and education for attorneys, particularly for juveniles. The other part of this bill is it also adds a juvenile expert, is what I'm going to call them, to the Michigan Indigent Defense Commission. So it'll expand it from 18 to 19. And let's see. I guess I'll take questions.
Do you have any members that have questions? Representative Johnson?
Thank you, Mr. Chair. I like the bill. What is a juvenile expert? Is my first question. Second one is, since we already are utilizing a DOJ grant, federal grant for training attorneys, in this case, is it possible to get some federal money for this also?
Well, in conversations with Kristen already, they are getting federal grants right now from the Department of Justice. They are partially using some of that already for education. This just, again, puts it into statute and brings parity to the system for juveniles and adults. And the juvenile expert, I think that's yet to be determined. You might have standards. I'll let Kristen.
Sure. Thank you, Representative. To use your terminology, it would add an additional commissioner to our commission. And in the statute, the amendment states that it would be chosen by the Children's Law Section of the State Bar, someone who is experienced in providing representation and very familiar and intimately familiar with the delinquency process and juvenile courts. So that would be, I think a juvenile expert is correct in that instance. In terms of federal funding, just to echo what Chair Lightner said, bringing parity, matching the state's obligation under the U.S. Constitution, under the state constitution, a litany of Supreme Court case law that we provide effective assistance of counsel, not just for adults, but also for youth. It doesn't matter your age. You have a due process right to effective assistance of counsel. Unfortunately, our state has not been living up to that obligation in the juvenile courts. And so that is absolutely the core of this bill and why it's so necessary. And in my presentation, I'll show you what we've been doing in the adult systems and the great impacts and success. And I can't wait we're very supportive. Our commission is very, very supportive of this expansion. In terms of federal funding, you're absolutely right. We were very successful to be able to get a 3-year grant that would help inch us towards providing training. Attorney training is one of the standards that we've set for our adult criminal trial courts funding units. I expect that to be the same for the juvenile attorneys when we are able to see this amendment happen and to expand into this work. It is a term-limited grant. I don't expect to see that same type of federal funding available in the near future. So that does make it a little difficult. The juvenile court caseload is a tiny fraction of the adult criminal caseload. So it's really, allowing us to work into this world. I think we've already created the system. I think that it wouldn't be a very large impact we can take this on without a lot of effort.
Yeah, and I just want to add to that, too, about the necessity for proper representation. In Michigan, we incarcerate kids at a higher rate than most any other state. And hopefully by having educated attorneys, that are specialized with juvenile issues, we can avoid that pipeline, again, and keep them in the community. Obviously, we also know there are times that removing them from the home is the best thing for them. But we'll have experts that can help us with that and hopefully decrease that population and get them on the right path.
Your Representative Hope.
Thank you, Mr. Chair. I want to thank Rep. Lightner and Ms. Staley for bringing this up so early on in the term. This was a very important piece of the juvenile justice reform, justice for kids and communities, and I was disappointed that it didn't make it through last term as well. So I appreciate it as an attorney and as someone who cares about kids.
Representative DeBoyer.
Thank you, Chair. You may very well touch on this in your presentation, but is there some sound data that we can demonstrate that by implementing this plan, it will reduce the long-term probability of further incarceration perhaps, or economic benefit to the individual, that kind of stuff. Thank you. Thanks for your testimony, by the way.
Absolutely, yes. And yes, in fact, there is. So thank you for kind of laying the groundwork for my presentation. We've been able to, as I'll talk about, we're still what I would consider a young agency. We were created in 2013, and we just began 6 years ago providing grant funding to local systems to develop these standards and implement them. But we've already started to collect data, tying that to national research that we've seen across the country. And yes, absolutely, there's a direct tie to having this effective advocacy at the front, ensuring that there's not necessarily a lesser count of guilty, not guilty, but a lesser sentence length. That we're able to, seeing better advocacy means that you're able to actually, help the judiciary make better have more consistent decision making. That there is more mitigation types of conversations talking about this person as a whole being, that they live in a community, that they have a family, and you're seeing it's not just people aren't making as many mistakes because there are effective. There are resources, support. Unfortunately, our state has had a long history of wrongful convictions, but we never had this type of support for the defense community. And so this is something that we've, that's one of the main goals as to why this is here, to make sure that we're not wrongfully convicting people, holding people in detention or incarceration where they don't need to be. Of course.
And Rep. DeBoyer, I also have this National Juvenile Defense Standards booklet. If you want to read through some of this data, it's got some good stuff in it. So thank you.
Okay, thank you to both of you for your testimony. Not seeing any further questions from our members, we'll go at ease.
All right, we'll be back to order. Next, I will read in cards. So I have, Kristen, she's speaking for the bill as well. I grabbed that one. Marlena David will also not wish to speak, supports the bill from the State Appellate Defender's Office. Rachel Richards from the Michigan League for Public Policy supports the bill, provided written comments and testimony, does not wish to speak. Tom Hickox from Michigan Catholic Conference supports the bill, does not wish to speak. Marianne Scully, the Galt Center, does not wish to speak, supports the bill. Nathan Triplett from the State Bar supports the bill, does not wish to speak. Beth Berglund, Michigan Transformative Collective, does not wish to speak, supports the bill. Michigan Collaborative to End Mass Incarceration supports the bill, does not wish to speak. Casey Stratton, Youth and Young Adult Advocate for the Michigan Disability Rights Coalition supports the bill, does not wish to speak. ACLU of Michigan supports the bill, does not wish to speak. MI Cure supports the bill, does not wish to speak. Jen Peacock of the Michigan Center for Youth Justice supports the bill, does not wish to speak. Paula Bowman and Denise Hartzell, League of Women Voters, supports the bill, does not wish to speak. Michigan Association of Treatment Court Professionals supports the bill, does not wish to speak. The Student Advocacy Center supports the bill, does not wish to speak. Then we have James Johnson of Michigan Association of Counties, does not wish to speak and is neutral on the bill. With that, we are going to go ahead and vote on the bill today because this is a reintro, significant bipartisan support. With that, I'm going to have Rep. Bagol move to report Bill 4070 with recommendation. Madam Clerk, would you please call the roll?
Chair Lightner.
Yes.
Representatives Bagol,
Yes.
Wozniak,
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shooty.
Yes.
Carter.
Yes.
Hope.
Yes.
Breen.
Yes.
Scott.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. House Bill 4070 is reported with recommendation.
Thank you, Madam Clerk. With that, we are going to go ahead and move on to the actual presentation by Kristen for the Michigan Indigent Defense. So go ahead and start whenever you're ready.
Sounds good. Thank you very much. And I'll reintroduce myself. Again, Kristen Staley. I'm the Executive Director of the Michigan Indigent Defense Commission. I'll jump right into what we do, and I'll also be discussing what we do, how we do it, and the impact that we've been seeing over the past handful of years since our existence. The MIDC, we are led and driven by the Michigan Indigent Defense Commission Act. We are required as a commission and an agency to develop and oversee the implementation of minimum standards on delivering public defense across the state. And it is specifically, at this moment, carved out simply for adults in criminal trial court levels, so at your district courts and your circuit courts. We administer grants across the state to our local systems so that they can comply with these standards that we have created as a commission. We help and provide technical assistance as a staff to make sure that we want to help educate as well as provide oversight. So we've literally been across the state building public defense offices, training attorneys, building brand new innovations and ways of providing public defense services since our existence. And we monitor and make sure that our minimum standards are complied with, that the grant money that we provide is being spent in the way that it's supposed to be. We collect and analyze data that comes back as part of our grant agreement, our grant contracts, showing that, that the grant money is being spent appropriately, but also to show our impact, that we are on target in terms of what we're doing, our standards are meeting the mark. And frankly, and lastly, but certainly not least, one of the mandates that we are given under our act is to encourage best practices. That allows us to be innovative, to be a leader in the field. And as I'll show you in a couple of slides, we've become a national leader in terms of providing public defense support and resources. My commission, we have 19 commissioners. It is a large representative of all stakeholders within the criminal legal system and those familiar with the criminal court process. I'm actually here today. My chair is Tracy Brame. She's our newly appointed chair of this year. She is the Associate Dean at Cooley Law School and the director of the school's Innocence Project. The commission is supported by a staff, which are a wonderful staff that I lead. I call us small but mighty. We are 18 people strong. We support our 19 commissioners and the 133 funding units across the state. We have a team of what I call our field team, which is consists of our regional managers. We split the state up into 6 regions. That regional manager is the first point of contact out in the field providing technical assistance. These are staff members who have been public defenders themselves, or they are attorneys and are really there as a wealth of knowledge in terms of helping systems think through these brand new ways of doing business, helping build up offices, helping with recruitment and retention of attorneys, working with our law schools, really building the idea of the public defense as a job that you want to have. We have a grants team that oversees the grant funding that we provide out to the systems. We have a grants director and 2 analysts. They see every single penny that goes out our door to the local systems. They also oversee the audits that we do on an annual basis, and we contract with a CPA firm to make sure that everything is being conducted appropriately. We have a research team of a research director and a research analyst that helps us measure our impact, helps local systems with their case management programs that they're developing, helps collect the programmatic data that we receive on a quarterly basis, making sure that our standards are having the correct impact. We have a deputy director who's also our training director and a training analyst who who also oversees the federal grants that we receive in terms of providing trainings for both adult attorneys and youth defense attorneys. The Youth Defense Project is a new one for us, and we have a program manager who's funded by that grant. And then we also have our legislative director, who's here with me today as well, Marcella Weststrait, who some of you may know, and who supports me on things just like this, and making sure that we're meeting all of our mandates within the statute, and ensuring that we are able to expand in ways, for example, like Bill 4070. The standards that the commission has, we have 9 standards the commission has approved, and all 9 standards have also been approved by the director of LARA. All 9 of these standards are now being implemented in the field. This is the first year where I can say that. Over the past handful of years since our existence, we've been slowly working with our local partners to implement these changes. These are very large systemic changes. The standards are based upon the national ABA recommendations for the appropriate delivery of public defense services, and they're very foundational. Unfortunately, before our office existed and these standards and the funding existed to support these foundational items did not exist. Our state was not supporting public defense in these critical ways. For example, we did not have state funding for continual attorney education and training. But now we have a standard on this. We now have a standard on requiring that attorneys must meet with their clients in a confidential meeting space and must meet with them within a certain period after they're assigned to the case. That funding for experts and investigators, which is critical and part of due process and effective assistance of counsel, will now be always funded and available to cases going forward. We have a standard that requires attorneys to be a part of all critical stages, including first appearance in court. That the delivery of public defense is independent from the judiciary, just like it is for the prosecution or retained counsel. We have our 2 newest standards that are being implemented right now are a capping of attorneys' workloads so that we can ensure that attorneys are not burnt out, that they're not overburdened with a massive caseload, so that they can abide by their ethical duties as attorneys to focus on the client right in front of them. And ensure that their mistakes are not made. We also are requiring now that attorneys are qualified to handle the case that they are given. No longer are we handing brand new law grads homicide cases, in terms of we want to make sure that you are qualified to represent the case that you are given. Again, ensuring effective assistance of counsel. And that these attorneys are reviewed for their quality. That we want to make sure that we're providing attorneys that are meeting a certain bar, not just because they're public defenders, but these are some of the most dedicated and best attorneys out there. We now adequately pay attorneys a living wage. Before our act existed and our standards were out being implemented, attorneys, in many instances, we saw were being paid $20 an hour, if not lower, because they were paid on flat fees. It didn't matter how many cases they were given or the intensity of the cases they were given. There was a great disincentive to do the work. Some places provided only fee for services, so you would receive $50 per motion or $700 or $1,000 for a trial. Again, a great disincentive to do quality work. Now attorneys are given a livable wage, either on par with the Attorney General's offices, Assistant Attorney Generals, or of a minimum hourly rate if they're contractors. And lastly, but certainly not least, we have an indigency determination standard so that no matter where you are in the state of Michigan, it is no longer justice by geography, that if you are of a certain qualification it's of a federal poverty level of 250% or lower, if you already receive state assistance in some capacity or federal assistance in some capacity, you will be eligible to receive public defense. Of course, to implement these standards, we need to help and support our local systems. We don't have unfunded mandates in this state, and frankly, we want to be able to support our local systems and meet our state's obligation to providing effective assistance of counsel. The defense funding comes from 3 pots. It is from our state grants, which is a part of general fund dollars. Our act requires that there's also a local component, a local share is what we call it, that local systems must also provide each year. It is a statutorily defined definition. It's a static number, and it hovers around $38 million or so each year. And then there are some systems that also collect attorney fees or reimbursement fees. Our indigency determination standard allows both a full determination or a partial. If a person is partially indigent, many of those systems that determine that also seek reimbursements and attorney fees. Our grants, as I mentioned before, we support people. We support attorneys, we support the paralegals, the administrative staff, social workers, people working within the courts that help us collect data, that help us ensure that clients are able to meet with their attorneys timely. As you see, over 90% of what we fund are jobs that never existed before in many ways, that we are providing jobs to people who protect these critical rights, these due process rights. We also are seeing, of course, funding that we have funding set aside that's dedicated for experts and investigators. While it's 3.5%, which of that large number, we are seeing that number increase each year. It's about changing culture. Again, this was never a dedicated pot of money. The standard never used to exist. So we're seeing a great change towards best practices of using experts and investigators on cases. Training, I've mentioned before, it's really the best bang for your buck. It's very inexpensive. We provide training based on federal grants, but also once we've trained our trainers and we have a great program set up, we're able to offer many of these programs for free. We also rely on many of our state partners out there that have all existed before. You'll hear from one, the State Appellate Defender's Office after me, or the Criminal Defender Association of Michigan. There's some, or national entities that exist. We've been able to increase and create policies on what we expect to see from trainers that are eligible, because every one of our attorneys must receive 12 hours of continuing education each year that is funded by these grants. And then, of course, there's always indirect costs, equipment, services. You need these things to run a public defense office, just like you would any other office. These are case management programs. These are services that keep the lights on, and other indirect costs that come associated with creating a county office or contracting with a nonprofit firm. Of course, every single dollar, as I mentioned, through these grants, we have an immense oversight and approval process that is continuous. I realize there's a lot of bullet points that are kind of small in this, but that's the point, to show you that really how intense our year is, and our staff is constantly focusing not just on the grant grant year right in front of us, but also last year's grant, the helping folks apply for next year's annual grant, because our statute requires an annual application and compliance plan from every local system. So our staff and the commission have to review and help these local systems apply every single year. And of course, not just oversight of dollars, but we have to make sure that every single system is continuing to comply with our standards. So we, of course, each year we have a grant agreement that sets up what every local system must abide to in terms of our reporting deadlines. We have a grant manual that is our policy manual in many respects, showing what the grants can and cannot be used for. This is updated every single February by our commission. We have a grant management system that is, I don't know how we could work without it, frankly. This is a system that is where all of our local partners, as well as our staff, that's where the grants are literally entered. That's where we're able to assess data. That's where reporting is done. Our field team conducts constant court watching and site visits, not just to the court, but to the jail cells, to the jailhouses, to meeting with the public defense teams and their offices. This is conducted in all locations across the state. We also, to ensure consistency of ensuring compliance, our research team has created a rubric that we use and make sure that we're updating every single year so we can measure consistent compliance from system to system. And again, I believe I already mentioned, we conduct financial audits with a contracted CPA team to make sure that we're getting everything right. So that's what we do, and that's how we do it. But I often get a lot of questions in terms of, well, what does it actually look like in public? What does our state look like for public defense in the adult systems? I mentioned we have 133 local systems. A local system, by definition, in our statute, is a trial court funding unit. So that's a county, that's a city, sometimes it's a township. I like to use the example of Wayne County is a system, that Detroit, the city of Detroit is a system, but the Grosse Pointes are also local systems as well. Our statute provides a lot of local control, as it should. Iron County is not Wayne County, and there's a lot of places in between in terms of what their public defense needs are, what their population's needs are, what their court system looks like, how many attorneys actually are eligible to be working in those places. So we allow and encourage diversity in terms of how every system can meet our standards. Because of that, we've seen many systems opt to actually create new county offices, county public defense offices, which has been fantastic to see. I myself, when in another role, I've been with this agency since 2017. I used to help out in the field and help build up these county offices. Some of these are regional offices that share resources across lines that cover. So we have public defense offices that cover 40 counties. The rest of the systems are managed or overseen by what we call managed assigned counsel administrators. Again, they're independent offices or perhaps contracted attorney firms, but they are independent of the judiciary. They're overseen by the county executive branch. And they assign counsel, they oversee the billing, they oversee assurance of the grant management. Across the state of Michigan, we now know exactly how many attorneys are conducting public defense work. This number changes pretty much every year. There's always attrition, people retiring or new people coming on board. Right now, we have about 1,700 attorneys that are practicing public defense. I do like to point out that is only 4% of all active Michigan attorneys across the state. However, about 85% of people walking into the trial level courtrooms are those who are eligible for indigent defense. So, the standards, since we've had them out, we've been able to collect a lot of information. This is very critical to ensuring, again, that we are meeting our mandates under our act, because we are supposed to collect and analyze this data, but we're also supposed to make sure that what we're doing is impactful and that we're on the target. One of our biggest changes to our local systems is that we require counsel to be at first appearance. So arraignments those are the stages, if you're familiar, where a person first enters courts, they hear the charge being read, they can plead guilty, not guilty, a bail is perhaps given, or someone is released on personal recognizance, personal release. Last year, we know that over 295,000 people were represented by a public defender or an indigent defender at arraignment, at first appearance. This is 86% of all arraignments that happened in the state of Michigan. Now, we are working on collecting Michigan-specific information. Again, we're still within our 6th year of grants, but we know, based on other very similar programs that are around the country, that national data shows that clients who have counsel at first appearance are 2 times more likely to be released without bail. That clients are 5 times more likely to be, if they do receive bail, there will be a reduction in price because of the advocate and the counsel that is with them. That clients who are released on bail, when they have counsel at first appearance, are much more significantly more likely to return to court. So it's not as though they're released and never show back up. But in fact, what this does is it reduces bail violations by nearly 2/3 with those clients. This, of course, relates directly to reducing pretrial incarceration, reducing the fact of jail beds and jail time, reducing budgets in terms of needs of housing people pretrial. Also, it allows people to go home so that they can continue to work at their job, to pay their rent or their mortgage, to ensure that if they have dependents, they're able to go home and provide for them, for their children, or maybe elder care. There are so many wonderful things that at this very critical moment, not just because of the increased advocacy, but the fact that this person is able to continue to be a citizen and not just be incarcerated while awaiting trial. We're also changing the culture of public defense entirely, frankly. We have seen, again, this goes to the encouragement of best practices, but also from a few of our standards, like the requirement of experts and investigator funding. For example, we've seen an increase of use of experts in cases just from last year, 41%. Now, while that number might be small compared to the amount of arraignments that we've seen, this is a huge change. You have to understand the use of experts and investigators was fairly uncommon, to say it lightly, in public defense cases, mostly because the funding just simply wasn't available, or there was not enough time or resources or dedication to actually be able to do this. Our grants also support work of defense teams and things like specialty courts, all sorts of really neat innovations that we're seeing popping up, like driver's license restoration programs or veterans courts, mental health programs. And of course, we've created a brand new position for those who work at the trial level advocacy work. We now have client advocates or social workers working along with the public defense teams. This is new for us in the state of Michigan. These jobs never existed. We now support 86 of those positions. These social workers help with client interviewing. They help with mitigation reports, ensuring that the entire person is being shown that if there's any types of mitigation circumstances, perhaps mental health issues, family issues, things that led a person into the criminal justice system, criminal legal system. And again, we see that national data, when you have all these types of innovations that are part of your public defense team, that we see significantly reduced rates of wrongful capital convictions by 19%. We see a massive increase of possibility of parole at the end of people's sentences, a massive increase of around 62%, which is what national data shows us. And again, we see about a quarter of clients receive a reduced prison sentence length. Again, not that they're found guilty or not guilty of a change, but the reduction in length, which again, equates to reduced incarceration costs, ensuring that people can come back rehabilitated and become productive citizens. I've talked about training, but I really can't talk about it enough. It really does shape culture. The fact our state of Michigan is one of the few states that does not require our licensed attorneys to have continual legal education. However, we require that of people who accept indigent defense cases now at the criminal trial level. This is raising the bar, if you will. This is changing what public defenders, what we expect of public defenders. Our office offers trial skills simulations programs. These are the federally funded grants. We've been operating one through Burn JAG grants for the past, I think we're in our 7th year now. And that's for the adult attorneys. We are in about a year and a half into our youth defense federal grant that will be ending in a year and a half from now. But we hope to incorporate as part of our portfolio of training that we offer. We average, putting those two programs together, we average about 2,500 to 3,000 hours of training for attorneys. And this is very hands-on skills program training where we can do mock simulations, mock trials. This is something that we hope helps qualify attorneys to be prepared for trials and for court work in the future. I mentioned we partner with a lot of numerous state and national trainers. They are very clearly our partners, and also share the goal of seeing increased effectiveness of counsel across the state. We've also done, we've partnered with Wayne State University, who I love to bring this up because it's unique across the country. Wayne State offers a holistic defense programming with their joint program between their law school and their social work school. They helped us create our very own Michigan Holistic Defense Fellowship that we are now in our 2nd year of operating. It provides spaces for public defense offices for 20 students, graduate students, who are half are in social work and half are in law school, and they receive a stipend for the summer, and are immersed into what it's like to work into a public defense office. We've already seen a few being recruited to come back and work. That means that we're keeping our Michigan law schools and keeping them in the state, providing them spaces. It helps us with our recruitment and retention, which is critical to ensuring that our local systems can meet some of our minimum standards. And we've also, our commission has allowed many internships to be funded and supported under our grant programming, again, to ensure that we're keeping our students here, that we're promoting the practice of public defense because it is such a critical service. At least 25 counties have been offering these programs, and it's been a great recruitment tool. And the reason, one of the biggest reasons that we need to continue to recruit and retain our attorneys is because we do have caseload standards that cap the amount of cases that one individual attorney can have a year. Our standard caps the amount of cases at 400 misdemeanors a year or 250 felonies. Now, some of you might think, well, gee, that's a high number. In some of our counties, however, those numbers are triple and have been triple. Some of our busiest district or circuit courts. I'm thinking like Oakland County, Wayne County, those types of places. You can only imagine the type of quality of, it's not as though the attorneys aren't dedicated to the work, it's just that the system was not set up to support effective advocacy with that type of high caseloads. And so the more that we're able to offer trained and qualified public defenders, a limitation on that caseload work, and ensuring that they're qualified to do this work, that we're much more able, data is showing us much more able to prevent wrongful sentences and wrongful convictions, to reduce disproportionate lengthy sentences within the prison. And we do have specific national Michigan data that shows that every dollar spent on hiring a new public defender to reduce these caseloads will save over $6 in return on incarceration costs in the end. Again, it's because of the reduction in terms of sentence length that we're able to have the best possible advocacy that we can provide folks who need that are defending against a criminal charge. And to make sure that they come back into society rehabilitated and, are productive citizens. I mentioned, it took us a long time to get here. This was not an overnight. There was a lot of people that come before me and come before our office that have been working on public defense for decades. This began in many ways with a really big push. In 2008, there was a national report that came out that did an estate assessment that showed that we were dismal. that we were not meeting our constitutional mandate, that we ranked very much at the bottom in terms of providing public defense services, and we're well under in terms of state funding to support effective counsel. Now, 15 years later, since our act was made public and our office existed, we are now at the top. There's a coined phrase of using the Michigan model in terms of helping other states come to this point. We are recognized nationally as transforming the way that public defense is delivered. And I know I've already talked about this bill and you've already voted on it, but it is a natural extension. We've seen a statewide assessment that said very similarly to where we were in the adult system, that we are dismal in terms of the inadequacy of what we're providing for young people and not meeting their constitutional due process needs. And we're at the right point to expand into youth defense services. So that's really what's on the horizon for us, and I'm happy to entertain any questions.
Thank you, Kristen. Rep. Wozniak.
Thank you, Madam Chair. Very impressive. Very impressive. So the question, I'm an attorney, so I'm relating these questions to the appointments of the attorney. How do they get appointed? They get vetted, I assume, but and then their activity is followed up from their courtroom performance. Do they cross over into the adult market also?
Sure. Yes. So a couple things. Yes, the appointments are all made independently from the judiciary. That's one of our main standards that happened a couple years ago now. So it's either, it depends on the system. It's either the appointing authority is, sometimes it's the chief public defender, sometimes it's the managed assigned counsel administrator. They're all independent attorneys who are who have a background in criminal defense. You are right. One of our newest standards is about the quality and continual review of performance. This is new this year. It's currently being implemented right now. Yes, there are standards, and again, each local system we have minimum standards. So many of our places are well above that bar, and it's wonderful to see. So yes, there is a certain contract that if you're an independent contracted attorney, you're on a roster, that you have to abide by certain contracts and agreements to work within that county. If you're a salaried employee of the public defense office, absolutely, you have to be qualified to even be hired as part of that team. And in terms of yes, it does cross over. Right now, we're only working within the adult systems, so this expansion into youth defense would be a brand new thing. There are attorneys doing this work, but they are not under our standards. They're not under our grant programming.
You used the word roster, and
Yep.
I know my experience in the probate system, people that get appointed by the courts, they're either appointed because there's a hierarchy, which allows them to garner all the cases, or they're randomized, which is my preferred method. Which one happens with you?
Right. No, you're absolutely right. That's one of the big reasons why we have our standards, because we don't like to have this hierarchy or bias. And it's before our standards existed, but there was quite a bit of that across the state. It's randomized. It is consistent. Some places, if you have fewer attorneys, if you only have one or two attorneys in the county, you're pretty clear who's going to get the case. But some places that have a much bigger, more robust roster, or employee roster in their public defense office, yeah, it's much more randomized, or it's given to people who specialize in certain types of cases.
Last question. The client advocates and the social workers, are they under your auspices, or are they appointed by the locals?
Yep. So it's all local. Our office, we do not provide direct service, and we don't oversee the attorney's work. So we contract with the local funding units, so the counties, the cities, the townships. But we know who's doing the work, and we're out there helping them do this. But yes, they are the social workers, the experts, the investigators. They are either hired on staff. So there's a lot of investigators full-time in public defense offices now, or in the social workers full-time on staff, or they contract. If you're a roster attorney, you're independent contractor. We help make matches, and we know who's doing the work out there. But no, we don't oversee that work.
Thank you. Keep up the good work.
Thank you very
Rep
much.
Carter.
Thank you, Madam Chair. Since Rep. Wozniak took all the questions, I'll just make a statement. So, as a person who worked in criminal justice, I worked at every courtroom in Wayne County, every jail in Wayne County. I've been retired 17 years. And I'll say this. This has been a long time coming, and it's a wonderful thing. And I'll just say this, Mizell Soul Sr. is probably smiling because he used to run the public defender's office down in Wayne County. And if you got a public defender back in the day, you were better off going to the casino. I'm just be honest with you, because your odds of seeing them regularly. I worked in an AOI courtroom, and there was no consistency. So this creates standards and expectations that you at least have a fair opportunity of competent representation. So I applaud you. Thank you.
Thank you, Representative. I appreciate it. And yes, you are correct. Yes.
All right, thank you, Kristen. We are going to have Marlena David from the State Appellate Defender's Office come up and go ahead and give your presentation. And sorry we went a little long, but
Sorry about that. Okay. Thanks.
important stuff.
Okay. Just give me the cut sign. May I begin? Yes. Good morning. Thank you all for having me here. I'm here to talk about the Michigan State Appellate Defender Office. My name is Marilena David, or you can call me Mari. And I'm happy to talk about SATO because I have been at the State Appellate Defender Office since 2007 when I began as an intern. So I've been there for quite some time, 18 years. I've been an attorney at SATO for 16 years and in leadership for the past 10 years. So happy to talk about what we do and happy to answer any questions. I should also say at SATO I'm currently the acting director and serving as deputy director, training director, and project reentry manager. Public defenders, they're the only constitutionally mandated attorneys in our country. It's a huge job with a lot of responsibilities, and at SATO we take our job very seriously. Historically, public defenders are the shield against governmental overreach, and we do know that public defenders, the role that public defenders serve, and especially appellate public defenders in our office, are looking at everything that happened at the trial level to make sure the Constitution was followed, statutes were followed, rules were followed, procedures were followed, and that people were guaranteed the fair trial that our Constitution says they are guaranteed. Our mission at SATO, throughout our 5 units that I'm going to briefly touch upon and tell you about, is to fight injustice through access, advocacy, compassion, and education. And we take our mission very seriously, ensuring that all clients who have been convicted, if they do want to appeal their trial, their conviction by a trial or their conviction by a plea, that they do have the right to an attorney to assist them with that appeal, and not only an attorney who's going to approach their case with excellence, knowledge, expertise, and compassion. We are the oldest, biggest, and only statewide public defender office and roster management system in the state. And we have all sorts of different ways that we serve our role. I'm going to tell you about a few of them. We've been in existence for 56 years. We are currently under the Appellate Defender Act and overseen by a 7-member Appellate Defender Commission. Our commission is 7 members, and it has appointments from all sorts of different areas like the Supreme Court and Court of Appeals and State Bar and so on. We have right now about 85 employees, and about 30 of them are public defenders, and 15 more are client-facing members like investigators, mitigation and reentry specialists, and paralegals and those type. We have saved the state of Michigan in 2024 $19 million in corrections costs through correcting reduced sentencing errors. And you all know the Michigan sentencing guidelines are very complicated. You have to score 7 prior record variables and up to 20 offense variables, and it's not always clear how they should be scored. And part of what we do on appeal is make sure they were scored correctly, and oftentimes they are not. And when they are not, we have to file motions, we have to get those corrected, and we go back for resentencing hearings, and we tell the judge, this is really what the guidelines should have been. Or in certain situations, Your Honor imposed consecutive sentencing when really you should have imposed concurrent, right? And we get those sentences corrected, and those results in reduced prison terms. And then we calculate that based on the cost of incarceration per year, which actually our estimate's a bit more conservative than the actual current cost. So we are saving the state of Michigan in those errors and bringing people back into the community under correct and accurate sentences. And SATO, in combination with our private counsel division of roster attorneys, which I'll talk about later, we represent 3,200 people each year on appeal. First, want to briefly talk about the public defender division of our office, and that is our direct appeals unit, juvenile lifer unit, and project reentry. Notably, our direct appeals unit just in 2023 expanded because there was an amendment to our Appellate Defender Act to expand us into youth defense. So kind of the topic you're hearing here today from MIDC, SATO is already there, and we're waiting for the trial level to catch up because kids at the trial level certainly need a right to counsel, and in appeals, that's happening now. We're building up our youth defense unit at SATO and at MAX, and jumping into that, and it's going to be wonderful to see the results. I will say that I had a personal family member that had a run-in with the youth system, and I was like, you have a right to this, and a right to an investigator, and a right to an expert, and a right to this, and they don't. Surprisingly, I was shocked by that. So many more rights in the adult system, and kind of none in the youth defense system. But we are definitely going to fix that. In our juvenile lifer unit, we launched in 2016 after a series of cases in the United States Supreme Court, most notably after Montgomery versus Louisiana in 2016. We launched our juvenile lifer unit, and it has been a gem addition to our office. We've been representing hundreds and hundreds of people who were convicted of offenses as kids and sentenced to die in prison, and who now are home back into the community as productive members of society. So I wouldn't talk about that. I also want to note to the court that it began with us representing people 17 and under. And then in 2022, there was a case in the Supreme Court, Michigan Supreme Court, that expanded that to those 18 and under. And then now there are 2 cases in the Michigan Supreme Court that are looking potentially to expand it to those 20-year-olds and 19-year-olds as well. So the juvenile lifer unit is growing because the case law requires us to do so, and we are there to be that constitutionally mandated counsel that those folks need. And then Project Reentry, no coincidence, also launched at the same time as our juvenile lifer unit, because it was recognized that we are asking people who were 15 years old when they were sentenced to prison to come home as 70-year-olds. And expecting them to stay home, right? Or figure that out, or know how to grocery shop, or whatever it might be. And so Project Reentry launched to fill that gap and to help, since we were bringing clients home, to help them stay home. And we offer workshops to clients on things like how to build credit, how to buy a home, how to file your taxes, how to, all sorts of things that people just don't know how to do. And our Project Reentry team is helping Michigan citizens stay home after very, very long incarceration stays as children. Our direct appeals unit, I just kind of wanted to give an overview. I don't know how familiar people are with appeals, but appeals are very complicated and also very long. And so these are just some of the steps that might happen in your regular direct appeal. And it starts with us getting the file, reading everything that happened at the trial level, investigating the things that weren't investigated in the first place, research and writing, meeting with our client, filing pleadings, and then the fun part is it kind of keeps going, right? You don't just stick in one court, and so sometimes you'll start in the trial court, then you have to go up to the Court of Appeals. They remand you back to the trial court, then you're back to the court. There's all sorts of back and forth, and the typical appeal can take anywhere from 1 to over 10 years. I have several clients I've represented for over 10 years, and so many attorneys in our office do, because appeals are not linear in any way. There are lots of back and forth. And one of the things that is unique to Michigan has one of the best appellate systems in the country, because attorneys on direct appeal in Michigan are not only allowed to expand the record on appeal, but we are required to expand the record on appeal when something should have happened at the trial level but didn't. For example, if a trial attorney should have called an expert witness on mistaken identification, but they didn't, right? It's our job as appellate attorneys to then find that expert, present that testimony to the trial court judge, and say, counsel was ineffective and should have presented this expert testimony. This person deserves a new trial. So that's part of the things, some of the things that are going on in direct appeals. And I also wanted to note that if we are successful on appeal, we are asking for a new trial. We are asking for a new trial where that unfairness or that constitutional violation did not occur. It's very rare that there would ever be an outcome of an appeal of like, okay, you're free to go, right, without any further procedure. So we are just asking for a new trial in most instances, or a reduced prison sentence in many instances as well. Some of the examples that I wanted to kind of highlight, this is an example of the type of case that we take. In this case, one of our attorneys, Maya, took a case to the Michigan Supreme Court. The court then vacated the judgment of the Court of Appeals and said that a trial court could not base a sentence in part on a refusal to admit guilt. And this is because we have a constitutional right to a trial, right? We have a constitutional right to a jury trial. We have a constitutional right to remain silent. So part of our work is to say if our citizens have constitutional rights, they are entitled to them and they shouldn't be punished for exercising them. I skipped over this one on accident, but this one, I'll go back, is another win that kind of shows what we do and what we're arguing here. And here is an instance where we are making sure that the courts recognize somebody's right to remain silent and also holding courts accountable for rules of evidence and admissibility rules and due process violations as well. And I mentioned ineffective assistance of counsel, and it's the most common claim that we raise on appeal is ineffective assistance of counsel. Even though we are seeing vast improvements in the trial bar, as was just recognized by MIDC, but keep in mind, we get every case in which somebody gets convicted, right? So we don't see the other cases in which people get diversion or other things like that. And so we are frequently challenging the effectiveness of counsel due to errors that we spot at the trial level. We also have a wrongful conviction unit, and recognizing that our role is also to ensure that people are not innocent inside of Michigan's prisons. It's also very hard to uncover wrongful convictions on direct appeal, but we do have a unit specializing in that. And here we have a picture on the left of Mr. Calhoun, who was exonerated after 16 years due to suppression of evidence of the suspect perpetrator's DNA match. And so he was exonerated after serving 16 years. And on the right, we have a picture of our wrongful conviction unit team and attorneys with Crystal Mulheron in the center. She was exonerated last year after DNA testing led to another perpetrator, and her attempted murder conviction was vacated. Our juvenile lifer unit and project reentry unit work hand in hand. As I was mentioning, in 2016, when we launched this unit, we began with about 193 clients, and those were 17-year-olds who had been sentenced to life without parole. And in Michigan, there were a total of there were about 365-ish people who were in that category. SATO ended up representing about 193 of those. So the 180 people that you see there is out of that initial 365 total, 180 were sentenced automatically to a term of years. So in these juvenile lifer hearings, there's only really one issue. Nobody's contesting the conviction. The only issue is this person going to end up with a life without parole sentence again, or is this person going to end up with a term of years sentence again? And the term of years sentence, if they get a term of years, can be anywhere from 25 to 40 on the minimum, and then 60 on the maximum. And so those are the questions going to these hearings. So we've had, out of those initial 193 clients, 43 contested Miller hearings. And that means that the prosecutor is seeking life without parole. They don't want to agree to a term of years, so they're seeking life without parole. Out of those 43 hearings, 34 have resulted in a term of years, meaning that the court, after hearing all of the mitigating evidence, decided life without parole is not a legally valid sentence for this person. And out of the 9 cases where the court did reimpose life without parole, 6 of those have already been reversed by the appellate courts. So you can see that the majority of cases that are going to Miller hearing are actually ending up in a term of year sentence. And these cases are incredibly expensive and time-consuming and resource-heavy. And so you see those numbers there on those stats. Our team puts a lot of work into this and representing these individuals, and has been very, very successful in getting term of year sentences imposed. And so since 2016, when the JLU started, we have reduced about 2,473 years in prison terms, and that amounts to over $94 million in correction savings. So there's a huge return on investment in the funding for our juvenile lifer unit versus what we're doing in the state of Michigan and bringing people home. These are just a few of the individuals. The gentleman in the middle is Mr. Wheeler. He was inside for 55 years. He came home just a couple weeks ago after serving 55 years for a crime he committed when he was 17, and he's 72 years old in that photo. We also just have most folks in this photo were 18, 17, 16 years old and served everybody here served over 26 years, and like I said, Mr. Wheeler has served 55 years. Our reentry team goes to the prison picks them up, helps them come home and go to the parole agent and report and do all of that stuff. So our reentry team is integral in that. And as I mentioned, also helping with financial applications for food stamps and housing and trying to direct them to different services. So our reentry team does not itself provide direct services, but we are matching people with service providers and trying to help them navigate along the way. The Michigan Appellate Assigned Counsel System is our private counsel division of the State Appellate Defender Office. MAX merged with SATO in 2015. So MAX was created in response to the Appellate Defender Act in 1981 and then merged with SATO in 2015. And Keely Blanchard is our new MAX administrator. She just started in October. She's fabulous. She was actually one of the attorneys that launched the trial skills training you heard Kristen talk about through MIDC. She had been doing a lot of that for the trial bar. And so Keely is now on our team running the MAX roster. And there are about 120 MAX roster attorneys statewide. And MAX roster attorneys represent the majority of people on appeal, about 75% of people appealing their felony convictions. There have been, over the years, so many improvements with MAX, and one of those I just wanted to highlight for this committee is a recent amendment to the Appellate Defender Act that helped pay roster attorneys reasonable fees for their work. Roster attorneys were similarly getting paid $25, $50 an hour, $75 an hour for work on appeals, and also not being paid for all of the work that they did on appeals because of presumptive caps. And so now with these amendments, attorneys are getting paid reasonable fees in line with what's happening at the trial level as well. I want to highlight very quickly these three things going on at the Michigan Appellate Assigned Counsel System unit of SATO. The first is this litigation support council that we have Stephanie Farkas in here. We had a grant that was a Burn Jag grant. It was very successful. We ran it for 3 years, and we established this litigation support council position in that role. Because MAX roster attorneys, as many of you might know, they're private attorneys who don't have a support system of a public defender office. They're running their own practice. They have to figure things out. They don't have colleagues to bounce ideas off of or figure things out in that way. And so we launched this position about 3 years ago under a grant so that this litigation support council can make sure that MAX clients too are receiving effective assistance of counsel, that their attorneys also understand complicated appellate rules and procedures, and they're writing briefs in a way that are, that the court requires them to be, all sorts of things like that. So the mentorship and support is critical. We need more of these positions, these litigation support positions, because we need to grow the roster. Right now, the roster is only about 120 people, and on any given day, we have about 100 people who are awaiting counsel, who have not yet been appointed counsel, but they're entitled to it because we don't have enough roster attorneys. And so we have a strategic plan or goal that over the next 5 years, we'd like to grow the roster to about 200 attorneys, which requires us to bring more and more attorneys on board, which requires more people like Stephanie to be able to mentor them, guide them, support them through their first initial cases to ensure they are following all proper appellate procedures. We also have Josh Peace, who's on our team, and he's our youth defense counsel for the Michigan Appellate Assigned Counsel System. Again, this was in response to the recent amendment to the Appellate Defender Act, and now children have an avenue to appeal their adjudications, and we truly hope that comes for the trial level, and all of those reforms come as well. We also have our mitigation and reentry position at MAX. We have two. Emily's one, but we have another mitigation specialist named Alana who is on our team serving the roster in mitigation. Now, what's really important to note is we launched this grant, this Burn Jag grant, about 6 years or so ago, and we've been getting funding from Burn Jag since that time. We're a little worried about continued federal funding through that grant right now, and so part of what I'll talk about in a second is our budget request that we make the mitigation positions part of our general fund because they have proven effectiveness, and trial courts are asking for more and more and more of this type of mitigation. And so I'll talk about that briefly in a second.
Mari, I want to wrap your presentation up by 11:45, and it's 11:42.
That's not a problem. No problem. We also have the Criminal Defense Resource Center, and our CDRC provides all sorts of training, newsletters, and support to criminal defense attorneys around the state. If anybody is interested in any of our resources, reach out to me. Our sentencing guideline manual is very popular, and one of the quotes here in your materials is just in court, a prosecutor was using our book, and the judge said he used it too. So everybody in the system is using our books to prison librarians, all sorts of things like that. We also unionized in 2023. That has been going great. We have wage increases for attorneys, and we have increased our leave policies as well. And I'll end on our 4 budget priorities. We have, the first one is implementation of SATO workload standards. SATO attorneys are overworked, just like every other public defender that we see. Even though we have caseload standards, they are way too high. We had a study from the National Center for State Court that indicated that our workloads really should be almost half of what they are now, and so we have a 3-year plan working toward that goal. We also have a current service baseline request that we get salary adjustments in parity for in the civil service. We also are requesting to shift those 2 max grant funded mitigation specialist positions to the general fund. Those, just one mitigation specialist saved the state over $40 million in correction savings, so it pays for itself. And lastly, we're asking for the ability to pay our interns. There's a huge dearth of public defenders and people interested in public defense, and payment is a problem for kids who are students who are interested in getting into the system and doing public service. And just about every other actor is paying their interns, like the Supreme Court and legislatures and prosecutors, but we do not have funds to pay our interns and would like to not be the outlier in that area. So thank you for listening. You have my contact information, and please feel free to reach out if you have any questions.
Thank you. I do have one quick question, and I mean, you were kind of alluding to it, but how many, I'm going to call them resentencing hearings, are left? Because I know, obviously, we started at a huge number. We've went through a lot of that. Then we added in 18-year-old or 17, 18-year-olds. So I'm just curious where we're at, because I know we're at basically the worst of the worst, because I've been in on a few of them.
I don't know if I would say necessarily the worst of the worst, the complicated of the complicated, I would say.
There you go.
But I think of the original, and I'll correct if I'm wrong, but I think of the original 17 and under, we may be at about 9 or so that
Okay.
are left to go. But then we have 100 plus more of the 18-year-olds that we're representing right now, too. So lots to go.
Rep. Wozniak.
Thank you, Madam Chair. Real quickly, the ineffective counsel and and also, I don't think you mentioned the purposeful aggressiveness of prosecutors results in appellates court, which you handle, and then frivolous cases. But overall, how would you reduce the number of appeals that you're handling? In other words, how do we get rid of your department?
Well, I hope you're not looking to get rid of my department.
No,
but,
I'm kidding.
No, I understand. Prosecutors are in charge of how many cases get put into the criminal legal system, right? They're presented with arrest warrants. They get to choose which cases to prosecute, which cases to dismiss, how, the felony level, misdemeanor level. So we don't have any control over that or what comes to us, but how do we reduce the number of appeals? I mean, we can reduce the number of people that get convicted by investing in the trial defense bar and making sure that the trial defense bar has the resources to put the prosecution's case to the test. I mean, that's what everybody wants, is to get this right. We want only the people that should be convicted to be convicted. And we want appeals where we see, there's nothing here to appeal, right? This was done correctly, but we're not there. I think we're far away from that.
Thank you, and thanks to both of you for presenting today and enlightening us with what you do. Seeing no further business before the committee, we stand adjourned.